I'm going to call Jenny Salisa.
For the short call on the Judicature Modernisation Bill. I had to practice that term several times because I was tripping myself up. Mr Chair, Labor supports this bill, however, we have some concerns. The New Zealand Law Society made a really considered submission to this bill, and one of the key submissions that they made was around the fact that the High Court rules should not be included in this legislation. So in that vein, Mr Chair, I'd like to address Part 1, Subpart 6, which is about rules of the court and miscellaneous provisions. Mr Chair, this bill proposes to retain the High Court rules, a document that is close to about 800 pages in terms of the schedule, which will preserve the status quo under the Judicature Act of 1908. But in addition to the submission from the Law Society, the Law Commission also recommended, Mr Chair, that the High Court rules should be taken out and not included in this legislation, but instead be made as regulations. Now, the government initially agreed with this recommendation, Mr Chair, which was seen as recognising that the High Court's inherent power to manage its own practice and procedures coexists with the rule-making powers provided in legislation. But, Mr Chair, I wonder if the Minister sitting in the chair can explain why the government changed their mind and changed their position on this issue. The High Court rules, by their very nature, will require a lot of amendments. And we just heard from my colleague, Mr. Su'a William Seol, that it took around about 100 years before we got to this stage of talking about this modernisation of this particular bill. It would be fair to say that we probably won't want to see the changes to the High Court rules taking quite that long. Other than in exceptional circumstances, delegated legislation should not be used to amend Acts of Parliament. And so I agree with both the New Zealand Law Society and the Law Commission that the High Court rules should not qualify as exceptional situations justifying this approach, and that it should be taken out and amended as regulations. Furthermore, Mr Chair, the inclusion of the High Court rules in this particular legislation is not consistent with the treatment of the other higher courts. The rules of the Supreme Court, as well as the Court of Appeal rules, are not included in legislation. So why is it that the High Court rules is not treated in the same way? Why the inconsistency? Perhaps the Minister can clarify this for us. This omnibus bill contains changes that are long overdue, and I welcome the changes that will enable our courts and our justice system to be easier to understand, be more effective, and one that makes justice more accessible to many more of our citizens in our democracy. I'd like to acknowledge the Minister that was in the chair just earlier on, Honourable Minister Amy Adams, for all of the work that she's done in getting this bill to this stage, as well as her Select Committee. They've done a lot of work on this bill. But more importantly, I'd like to thank the Minister for agreeing to my colleague Jacinda Ardern's SOP number 62. We believe it is crucial to refer in the purpose of clause of this bill to a commitment to parliamentary sovereignty, the rule of law, judicial independence, and indeed the Treaty of Waitangi. This was previously a serious omission from this bill, and I'm glad it is now included. Mr Chair, I'd also like to talk briefly about Clause 167, which Dennis O'Rourke spoke about before, which, if introduced, would require every final judgment of a senior court to be published online unless there was a reason not to do so. The Select Committee spent some time discussing Clause 167, and there was some discussion that it would be, in fact, included. However, the decision was made to delete Clause 167. And, Mr Chair, I'd also like to know, in this technological age where most people would expect that when judgments are made, and if they're made available, that it would be on the internet, it would be great to know from the Chair why it is that they decided to delete Clause 167. Thank you, Mr Chair.